Get your hands where I can see them. Both of you. Now. Reed Colton had been running this stretch of road for 19 years. He knew every pothole, every speed trap, every blind curve between mile marker 9 and 14 on Corridor 14 heading out of Millhaven. He thought he knew exactly what kind of people drove a blacked-out Range Rover through his county on a Tuesday afternoon. He was wrong about everything that mattered. If this story sounds familiar, stay with it. The part you don't know yet is the part that changes everything. The afternoon heat pressed down on the asphalt like a flat iron. The kind of heat that made the road shimmer and bend at the edges, that turned the air itself into something thick and unfriendly. But Naomi Voss-Carver had been watching it through the passenger window for the last 40 minutes. The flat geometry of rural Alabama rolling past. The billboard for Harlan Pierce personal injury law standing tall and sun-bleached at the curve before mile marker 11. The hand-painted churches with marquee signs that hadn't been updated since spring. She was not thinking about the heat. She was reading the small laminated notice mounted on a metal post just inside the county line. They had passed it doing exactly 53 miles per hour, and she had read it at 53 miles per hour, the same way she read everything, completely, once, without needing to read it again. Notice: Millhaven County Traffic Enforcement Corridor. Officers operating on this route are required to document specific probable cause prior to initiating any vehicle stop. Alabama Rules of Criminal Procedure, Rule 3.1. She had said nothing to Marcus when they passed it. She had simply noted the sign's position relative to the billboard, relative to the gravel turnout 40 yards ahead, and then looked back at her phone. Marcus drove the way he did everything, without wasted movement. Left hand at the wheel. Speed exactly right. Music low enough to be ambient. He was 3 years older than Naomi and 4 inches taller, and he had the particular stillness of a man who had learned, a long time ago, that stillness was a form of protection. "You're quiet," he said. "I'm thinking." "What about?" She glanced at the rearview mirror. A patrol cruiser had pulled out of a gravel turnout approximately 6 seconds after they passed it. "That," she said. Marcus checked the mirror. The cruiser was not running lights. It was simply following, close enough to be intentional, far enough to appear casual. "We're clean," Marcus said. "I know." "Speed is right." "I know." The cruiser closed the gap by half. "He's been sitting in that turnout since before the billboard," Naomi said. She had seen the vehicle when they were still 200 yards out, the hood glinting just past the edge of the Pierce Law advertisement. She had registered it, filed it, said nothing. "He pulled out 6 seconds after we passed." Marcus exhaled slowly. 6 seconds. Not 4, not 8, 6. He needed a moment. A moment for what? To decide. The lights came on. Marcus pulled the Range Rover onto the shoulder without being told twice. Clean, careful, full stop. He put the vehicle in park, lowered all 4 windows exactly halfway, enough to be cooperative, not enough to be careless, and placed both hands on the top of the steering wheel where they could be seen from 15 feet away. Naomi had already put her phone face down in the cup holder. She had already unclipped her shoulder bag and placed it between her feet on the floor mat. She had already noted the time on the dashboard clock. 14:06. The cruiser sat behind them for 1 minute and 40 seconds before the door opened. Naomi counted. She counted everything. Deputy Reed Colton was a wide man who moved like he owned the pavement beneath his boots. Thick through the shoulders, thick through the jaw, a buzz cut silvered at the temples. His belt was loaded, radio, baton, sidearm, 2 extra magazines, a taser. He walked up to the driver's side with the particular gait of a man who had never once been told no on this road and did not expect today to be different. He did not approach the window. He stood 2 feet behind Marcus's door, which meant Marcus would have to twist to look at him directly. A small power geometry. Deliberate. License and registration. Not a question. Marcus turned his head at the angle required. He did it without comment. Good afternoon, officer. He reached for the center console in a slow, visible arc and produced both documents, extending them out the window. Is there a problem? Colton took the documents without looking at them. He was looking at the interior of the vehicle, scanning. His eyes moved from the back seats to the cargo area, to the center console, to Naomi. He looked at Naomi for 3 full seconds longer than necessary. Ma'am. Good afternoon, Naomi said. Colton looked back at Marcus. Where are you coming from? Atlanta. Visiting family in Decatur, heading back. What family? My family. A pause. Colton's jaw shifted. What's the purpose of your travel today? Marcus kept his voice level. Family visit. Returning home. Colton held up the license and registration without appearing to read them. This is a Georgia plate. Yes, sir. Long way from Georgia. About 2 hours, yes. Colton handed the documents back without glancing at them. He had never glanced at them. He looked instead at the Range Rover, at the trim, the rims, the factory paint that had cost what his cruiser was worth. Yet something moved behind his eyes. Something Naomi had seen before, in other faces, in other states, on other roadsides. Step out of the vehicle, please. Marcus did not move immediately. Officer, could you state your probable cause for this stop for the record? Colton's right hand moved to the top of the door frame. His knuckles were pale. I asked you to step out of the vehicle. I heard you, Marcus said. I'm asking what you observed that justified the stop. Alabama Rules of Criminal Procedure, Rule 3.1 requires... I don't need you quoting rules at me. Colton's voice dropped into something quieter and more deliberate. Quieter was worse. I observed a potential window tint violation. Now step out. Marcus looked at Naomi, a look that said, we both know where this goes. For he opened the door and stepped out onto the gravel shoulder in one smooth motion, hands visible, nothing in them. Colton pointed to the rear of the vehicle. Stand at the trunk. Marcus walked to the trunk. Naomi opened her door and stepped out. She had not been asked to. She did it because remaining inside a vehicle while a confrontational officer managed her companion alone was a worse configuration. She stood on the passenger side, her bag hanging from one shoulder, both hands loose at her sides. Colton looked at her sharply. I didn't say you could exit. You didn't say I couldn't, she said. Her voice was the same temperature it had been when she said good afternoon. I prefer to stand. A beat. Colton filed that away somewhere and did not respond to it. He went back to the driver's side window and where a tint meter, a device he kept clipped to his visor, should have been retrieved. He did not retrieve it. Instead, he walked a slow circle around the vehicle, running one hand along the passenger panel as he went. Not checking anything. Just contact, establishing that he could. Where are you employed? He called back toward Marcus. Private sector, Marcus said. Colton stopped. Private sector, that covers a lot of ground. It does. Naomi watched Colton's eyes move to the slight rectangular outline visible through Marcus's jacket fabric. The shape of a wallet or an ID holder or something else. Colton's expression did not change, but he held his gaze on that spot for just a half-second too long. Then he moved to the rear of the vehicle and stood beside Marcus. "Open the cargo area." "Do you have consent to search?" Marcus said. "Or a warrant?" Colton turned to face him directly. He was slightly shorter than Marcus, but he used the space between them differently. Forward in his weight, chin level, the specific posture of a man who relied on physical proximity to communicate authority. "I don't need your consent to conduct an inspection based on probable cause." "What's the probable cause for a cargo search?" Marcus said. "You stopped us for a window tint. The windows are the windows." Colton stepped closer. "I'm detecting the odor of a controlled substance." Marcus said nothing. Naomi, from the passenger side, said quietly, "The windows have been down since before you approached." Colton turned to look at her. "If you're detecting an odor," she said, "it's from an open window, which means it would need to have been strong enough to reach you from a distance." She paused. "Was it?" Colton walked toward her. He closed the distance in 4 steps until he was standing at the front of the vehicle, close enough that she would have had to crane her neck slightly to maintain eye contact. He was the kind of man who understood that vertical proximity was its own form of pressure. "Ma'am, I'm conducting a lawful traffic stop. You are required to present identification." She reached into her bag, slowly, 2 fingers only, and produced her Georgia driver's license. She held it out to him. He took it. He looked at it. He looked at her. "Naomi Voss-Carver." "That's right." "Relation to the driver?" "Sister." Colton turned the license over, looked at the back, looked at the front again. "What do you do?" "I work." "Where?" "Atlanta." "Doing what?" Naomi held his gaze. "Documentation." Colton stared at her for a moment that lasted longer than any stare before it. She did not look away. She did not shift her weight. She stood with her bag on her shoulder and her hands at her sides and looked at him with the same expression she had used to read the lampinated sign at the county line. Complete, thorough, without needing to do it again. "Stay here," he said. He walked back to his cruiser. Pause for a second. Because what happens in the next 10 minutes is the kind of thing you have to hear to believe. Don't go anywhere. The first thing Naomi did when Colton's back was turned was look at the body camera mounted on his left chest. It was a standard department issue unit. She knew the model. The indicator light that should have shown a solid blue recording signal was dark. She did not say anything. She noted the time on her watch. 14:09. She reached into her bag, the one Colton had not asked to search, the one she had kept deliberately on her person, and withdrew a small navy notebook and a pen. She uncapped the pen and wrote 3 things in the margin of a page that already had writing on it. 14:09, BWC unit, Colt badge 1147, indicator dark, no glow. Stop initiated, no documented infraction observed. Cargo search requested, no warrant, consent withheld. Marcus was watching her from the rear of the vehicle. His expression did not change. He had seen her do this before. Not the same notebook, not the same road, but the same motion, the same calm. He had asked her about it once, years ago. And she had said, "Paper can't be erased by a power outage." He had not asked again. Colton returned from the cruiser. He was holding Marcus's license and registration, and he was also holding a handheld radio, which he kept by his side. He had called in the plate. Naomi could tell by the slight change in his posture. The plates had come back clean, the names had come back clean, and he had not gotten what he wanted from dispatch, and now he was deciding what to do with that. He walked to the back of the vehicle and stood in front of Marcus. "Mr. Carver, I'm going to ask you one more time to open the cargo area. And I'm going to ask you one more time for the specific articulable facts supporting probable cause for a cargo search," Marcus said. "That's my right under the Fourth Amendment." Colton set his jaw, eyed the odor. "An odor you detected from your vehicle," Marcus said, "while our windows were open, from a distance of at least 3 car lengths, on a road with active traffic. Is that your testimony?" Colton's right hand came up fast. Not a strike, not quite, but a grab. He seized Marcus's left forearm just above the wrist and yanked it toward the cargo handle of the Range Rover. "Open the hatch." Marcus's arm did not move. His feet did not move. He had the kind of physical presence that made grabbing him feel less like control and more like grabbing a wall. He looked down at Colton's hand on his arm and then back up at Colton. "Officer, you are touching me without legal justification. I am not resisting. I am not threatening you. Remove your hand." Colton held the grip for 3 seconds that felt like much longer, then released. He stepped back. His jaw was working. From the passenger side, Naomi had not moved. She had written one more line in her notebook. 1417, officers C physical contact, driver's L forearm. No resistance, no threat, unprovoked. It was the sign that saved the next 40 seconds from going somewhere else. Not a metaphorical sign, a literal one. A laminated card, weathered at the corners, mounted on the wooden post next to the guardrail 10 feet past where they were standing. It had been there long enough to fade, but not long enough to be removed. Naomi had noted it when they pulled over, the same way she noted the body camera and the gravel turnout and the Pierce billboard. Colton had turned back to the cargo area and was about to speak again when she said, without raising her voice, "Officer, the posted notice at the county line and the notice on that post." She nodded toward the faded card. "Reference, Alabama Rules of Criminal Procedure. Rule 3.1, which requires officers to articulate specific probable cause before conducting a stop on this corridor. You have articulated window tint and an odor." Colton turned. "The tint." She held her hand out toward the rear passenger window. "Alabama Code Section 32-5-215, B. Minimum visible light transmittance for rear side windows is 32%. The factory specification on this vehicle is 35%. The documentation is in the glove box." Colton stared at her. "The odor?" She kept her voice the same temperature it had been the entire time. "You would need to specify the substance, the intensity, and the proximity at which you detected it in order for that to constitute articulable cause. Those specifications would be subject to documentation." A long silence. A semi-truck passed on the road. The sound of it filled the gap between them and then faded. "Who are you?" Colton said. It was not quite a question. "I told you, Naomi Voss-Carver. I do documentation work." He looked at her for a very long time. Then he looked at Marcus. Then he reached for his radio and said, in a voice designed to sound casual, "Frank, send Becht out to Corridor 14, mile marker 12. Got a situation." He clipped the radio back to his belt. He looked at the two of them, at the clean car, the visible hands, the woman with the notebook and the steady eyes. And something moved across his face that was not quite doubt and not quite recognition. But it was the first edge of a feeling he would not fully understand until much later. "Neither of you goes anywhere," he said. He walked back to his cruiser and sat in it, and they could see through the glass the shape of him on his phone. Naomi wrote, 1419, requested backup. No charges filed, no contraband found, no consent given. Marcus said very quietly. He didn't run his tint meter? No. He doesn't have one? Probably not. A pause. How long until backup gets here? Naomi looked at the road ahead, the flat stretch of it, the heat shimmer, the billboard for Pierce Law catching the afternoon sun in the distance. 7 minutes, she said. Maybe 8. How do you know? She capped the pen, put the notebook back in her bag, adjusted the strap on her shoulder. I know this road, she said. Sergeant Nora Becht arrived in 6 minutes and 40 seconds, which meant she had been close, possibly already on the corridor, possibly in the habit of staying close. She was a compact woman in her mid-40s, with a close-cropped helmet of dark hair and the kind of face that had been professionally neutral for so long it had forgotten other configurations. She parked behind Colton's cruiser, walked to where he stood, conferred briefly in a voice too low to carry, and then walked toward Marcus and Naomi with a clipboard she had not gone back to her vehicle to retrieve. She had brought it with her. Mr. Carver, Miss Voss-Carver. Her voice had the finish of someone who had once been trained in de-escalation and had since decided de-escalation was a tool to be deployed selectively. I'm Sergeant Becht. I've been asked to assist Officer Colton with this stop. I want to explain the situation to you. Please, Marcus said. Officer Colton has reasonable articulable suspicion, consistent with Alabama Rules of Criminal Procedure Rule 3.2, that this vehicle may contain contraband. That suspicion authorizes a brief detention for investigation. You are not under arrest. You are being detained. On what specific articulable facts is that suspicion based? Naomi asked. Beck turned to her with the patient, unhurried expression of someone who had answered a variant of this question many times and had a practiced response ready. Ma'am, I understand you may have some familiarity with legal procedure, but you are not an attorney of record in this jurisdiction, and I'm not here to debate. I don't need to be an attorney of record, Naomi said. I just need to read. She reached into her bag and withdrew a single folded sheet of paper, not her notebook, a different document, crisp, printed, with a header she did not display, and unfolded it to a specific paragraph. Alabama Rules of Criminal Procedure, Rule 3.2, subsection A. A lawful detention requires that the officer be able to articulate specific, objective facts, not generalizations, not hunches, that, combined with rational inferences from those facts, reasonably warrant the belief that the person detained is engaged in criminal activity. She looked up. Specific, objective, facts. Becht's mouth had closed into a line. Officer Colton articulated 2 things, Naomi continued. Window tint, which I addressed by citing the applicable code section, and an odor, which has not been further specified, and those are the facts on record as of this moment. She paused. If there are additional facts, I'd like to hear them. A pause long enough to be a statement. I'd also note, Naomi said, almost as an aside, that Officer Colton's body camera has been inactive since 1409. He initiated this stop at 1406. The stop is therefore not on record for those first 13 minutes. Beck did not look at Colton. She kept her eyes on Naomi. Body cameras malfunction, Beck said. Yes, Naomi said. They do. Another pause. Beck made a note on her clipboard. What she wrote, they could not see. We're going to need you to come to the station, Beck said, for further processing. Marcus said, on what charge? No charge at this time. And this is an investigative detention pending. The maximum duration of a Terry stop under Alabama law, Marcus said, is sufficient time to confirm or dispel the suspicion that justified it. You have been unable to articulate the specific suspicion. The window tint has been addressed. The odor has not been elaborated upon. What specifically are you investigating? Beck looked at him, then at Naomi, then at the vehicle. Something shifted in her calculation, not a retreat, but a reorganization. She took a step back and spoke into her radio. Low, directed at Colton. A single instruction. Colton walked up to the passenger side of the Range Rover and reached through the open window. He did not ask. He reached in and picked up Naomi's bag from where she had placed it on the passenger seat. Naomi turned. Officer, that bag is not... Colton pulled the bag out through the window. I'm securing potential evidence. You have no basis to search that bag. Put it down. He held it by the strap, away from his body, and unzipped the main compartment with his other hand. What happened in the next 4 seconds was not loud. It was not dramatic in the way those things are sometimes dramatic. Naomi stepped forward, one deliberate step, and reached for the bag with both hands. Colton pulled back. He yanked the bag away, and the strap, still looped over his forearm, swung outward. And the rigid corner of the bag caught Naomi across the left cheekbone. Not a strike, not intended. But it connected, and her head snapped sideways, and she stepped back one step and touched her face with 2 fingers. A white-hot silence descended on the shoulder of Corridor 14. Marcus did not move. He held absolutely still. The particular terrible stillness of a person choosing, very consciously, not to react, because reacting was what they wanted. Naomi lowered her hand. There was a mark on her cheekbone, deep red, already swelling at the edge. She looked at Colton. She looked at the bag in his hands. "Write that down," she said, to no one in particular. Her voice had not changed temperature. The time is 14:24. Officer Colton made physical contact with my face while seizing my personal property without consent, warrant, or probable cause. That is documented. Colton's face had gone the color of old brick. He looked at the bag. He looked at her cheek. He looked at Becht. Becht had gone very still. "Bag goes in the cruiser," Colton said. His voice had acquired a slight vibration. "Both of them in the back seat. We're going to the station." "You cannot place us in your vehicle without..." Marcus began. Colton rounded the rear of the Range Rover in 3 strides, crossed the shoulder gravel, and got in Marcus's face from 8 inches. I said, "We are going to the station." Each word separated and driven in like a nail. "You want to test whether I need a reason? You're welcome to. You want to find out what this road looks like at 2 in the morning? You keep talking." Marcus held his gaze. He did not lean back. He did not move at all. He just looked at Colton, at the red face, the working jaw, the hands that wanted to be fists, and said, with a patience that somehow made it worse, "I want this conversation recorded. Get in the car. I want..." Colton grabbed Marcus by the jacket collar, both hands, he twisting the fabric, and walked him backward 3 steps into the rear door of the cruiser. Marcus's back hit the metal with a sound that was flat and hard. He exhaled once, sharply. "Get in the car," Becht said from across the shoulder. "Read." 1 word, a temperature in it. Colton released Marcus's collar and stepped back, smoothing his own shirt with both hands as if that tidied things. Marcus turned and got in the back of the cruiser without another word. His face was unreadable. Naomi walked to the cruiser under her own power. She paused at the rear door and looked at Becht. "Sergeant, I want it noted that we are entering this vehicle under protest, without being charged, and that the seizure of my personal property was not consented to. Becht said nothing. She wrote something on her clipboard. Naomi got in. The doors closed. In the Millhaven County Police Department was a flat-roofed building on the far end of Main Street, sandwiched between a hardware store that had been half converted to storage and a diner whose sign had been dark since before either of them had been through this town. The parking lot was hot asphalt and thin shade. 3 cruisers, a flagpole, a bulletin board behind glass near the entrance that held a cluster of notices. Most of them too faded to read through the glare. One of them was not faded. It was recent. Naomi read it through the cruiser window as they pulled in. Millhaven Police Department, Community Policing Initiative. This department is committed to constitutional, bias-free policing. Citizens' rights under the 4th and 14th Amendments are respected. Questions or concerns may be directed to internal affairs at number below. She read it once. She did not read it again. The booking area was beige and fluorescent and smelled of industrial cleaner and old coffee. A civilian desk clerk looked up when they were walked in, looked at Marcus and Naomi, looked at Colton, and looked back down. A small transaction. Familiar. Colton dropped Naomi's bag on the processing counter. Becht set her clipboard beside it. Naomi noted the time on the clock above the door. 14:41. She noted that there were 2 cameras visible in the booking area, one above the entry, one above the counter. She noted that there was a 3rd camera in the hallway beyond the door marked Processing, its housing positioned to cover the full corridor. Its indicator light was green. She noted all of this the way she noted everything. A holding room was a room with a table, 2 chairs, a bolted-down ring on the table surface, and a smoke-yellowed mirror along the east wall. Naomi sat in one chair. Marcus was not in this room. She could hear, through the wall, the particular acoustics of another room. A voice that was Colton's, doing something with a form. She had been told to wait. She was waiting. She had her notebook back. Becht had kept the bag, but allowed the notebook and pen, probably because it looked like a personal journal, and because taking a woman's notebook made paperwork that nobody wanted. Small calculation. She knew the logic. She had written 4 more pages since they left the road. A young female officer pushed the door open with her shoulder. She was carrying 2 paper cups of water, not bottled, from a tap. And she set both of them on the table with the careful deliberateness of someone performing a small kindness in a place where small kindnesses required courage. Her name tag said Pruitt. She looked at Naomi's cheek. The swelling had deepened to something that would bruise by evening. She looked at the notebook. She looked at the 2 cups of water. She opened her mouth. The door opened again behind her. Captain Delia Marsh had the build of a woman who had spent 30 years in rooms where she was the only one of her kind, and had decided that the solution to that was to take up more space. She was in her mid-50s. Gray-streaked hair pulled back, and she wore authority the way some people wore a coat. Not for warmth, for coverage. Pruitt. One word, a temperature in it. Pruitt turned. Something crossed her face, a flicker that was not quite conflict and not quite submission. And she walked out of the room. The door closed behind her. Marsh sat down across from Naomi. She put both hands flat on the table. Miss Voss-Carver, I want to apologize for the friction during the stop. Officer Colton is... A practiced pause, enthusiastic. He has 20 years of service, and sometimes that translates to an excess of caution. An excess, Naomi said. In your case, yes. I want to make sure we can resolve this quickly and get you back on the road. I'd like to make a phone call. Absolutely. Our system has been experiencing some connectivity issues this afternoon, but we're working on it. Probably another... A glance at her watch. 30 minutes or so. Naomi wrote in her notebook, 14:41. Phone call denied. Reason given. Connectivity issues. Captain Marsh, present. Marsh watched her write. What is that? Notes. A pause. Notes on what? Everything, Naomi said. Marsh held her gaze. She was a woman who had held many gazes in her time and knew the difference between civilian nervousness and something else. She was not certain yet which category Naomi fell into. We'll have the connectivity issue resolved shortly, Marsh said. She stood. Can I get you anything in the meantime? No, Naomi said. Thank you. Marsh left. Harlan Pierce arrived at the station at 15:22. Naomi had not met him before and had not been told he was coming. No one had mentioned him. But when the door to the holding room opened and he walked in, she understood his function immediately. Not because of what he looked like, because of what he carried. Pierce was 60, lean, silver-haired, wearing a suit that had been expensive when new and still suggested expense. He carried a soft leather briefcase, and he set it on the table and opened it with the relaxed efficiency of a man who had opened briefcases in rooms like this room many times. He had a manila folder. He set it on the table. He had a single sheet of paper, face down. He set it beside the folder. He sat down and looked at Naomi with the expression of someone about to do her a considerable favor. Miss Voss-Carver, my name is Harlan Pierce. I'm an attorney, and I've been asked by the department to represent the department's interests, Naomi said. A beat. To help facilitate a resolution. What resolution? Pierce opened the manila folder. Inside was a document, 2 pages, small text, and with a header that said, Mutual release of claims and agreement not to sue. He turned it to face her. This is a standard document. Both parties agree to release all claims arising from today's incident. In exchange, you and your brother are free to go immediately. No further processing. Your property is returned. No report is filed. Naomi looked at the document. She did not touch it. Read me Clause 4, B, she said. Pierce's expression did not move. He looked down at the document, found the clause, and read. The releasing parties agree to waive any and all claims, demands, damages, actions, or causes of action of any kind, civil, administrative, or otherwise, arising out of or related to the events of... He glanced at a filled-in date. Today's date, including any claims against officers, agents, employees, on or contractors of Millhaven County. Any and all claims, Naomi said. That's standard. Administrative claims. It's including internal affairs complaints, Naomi said. Is that your reading of administrative? A pause. That is one interpretation. It's the operative one. Naomi looked at him across the table. Mr. Pierce, if I sign this document, I waive my right to file a complaint with Internal Affairs about what occurred on Corridor 14 today, including the unauthorized search, including the physical contact, including the bodycam gap. Pierce closed the folder. You're making this more complicated than it needs to be, he said. I'm making it exactly as complicated as it is. She placed her hands flat on the table, mirroring exactly the posture Marsh had used an hour ago. I'm not signing it. Pierce leaned back. He recrossed his legs. He looked at the briefcase and then back at her with an expression that had shifted. Not to anger, not quite. but to something more considered, and therefore more instructive about what he actually was. "Your brother has a licensed concealed firearm in that vehicle," he said. "Georgia carry permit, technically valid. But we're in Alabama. Alabama Code Section 13-1173 requires a state license for concealed carry within Alabama borders. And while there is reciprocity with Georgia under certain circumstances, that reciprocity is, well, it's open to interpretation." Naomi held his gaze. "It's not open to interpretation. Alabama Code Section 13-1185 provides reciprocal carry recognition for Georgia licensees. It's not ambiguous." Pierce smiled. It was not a friendly smile. It was the smile of a man acknowledging that he had tried a door and found it locked and was now deciding whether to try the window. "You know your codes?" he said. "I know this one," she said. He picked up the release document and put it back in the folder. He put the folder back in the briefcase. He closed the briefcase with the same relaxed efficiency he had opened it with. "I'll let Captain Marsh know you weren't interested," he said. "Please do." He stood. At the door, he paused without turning around. "Ms. Voss-Carver, this county has a particular way of handling things. Cases get complicated. People's schedules get disrupted. Records get delayed." He did pause then, just a half beat. "I've found that people who cooperate early tend to have much smoother experiences." The door closed behind him. Naomi opened her notebook to a fresh page and wrote, 1522, Pierce, Harlan, attorney, presented mutual release. Clause 4, B, waiver of administrative claims. Declined, implied threat records delay. Departure, 1531. She looked at the clock. 1531. The connectivity issue was apparently ongoing. If you've made it this far, you already know this story is different. Keep going. The part that changes everything is coming. Marcus was in a room on the other side of the building when Colton came back. He had been sitting for 2 hours and 15 minutes. He knew the time because there was a clock on the wall, and he had been watching it. When the door opened and Colton walked in alone, without Becht, without Marsh, without any paperwork in his hands. He walked in and stood by the table, and Marcus looked up at him, and neither of them spoke for a moment. "You think you're smart," Colton said. Marcus said nothing. "Coming through here with your out-of-state plates and your lawyer talk." Colton's voice had the texture of something that had been simmering for the past 2 hours and had reduced down to something harder. "You think you're the first?" Marcus kept his eyes on the clock. "I've been on this road 19 years, Colton said. "I've seen your type 100 times. Nice car, nice suit. Act like you know everything." He stepped closer to the table. "You know what every single one of them had in common?" "I'd like a witness present," Marcus said. Colton slammed his palm down on the table. The flat report of it echoed in the small room. "You'd like a what?" Marcus looked at him. "I'd like a witness present for this conversation. I'm requesting that formally." Colton leaned over the table. "This isn't a conversation. This is me telling you how things work." "I understand," Marcus said. "I'd still like a witness." Colton reached across the table and grabbed Marcus's collar. The second time today, the same grip, the same torque, and hauled him half out of the chair. "You're going to sit here," Colton said, close enough that his breath was in Marcus's face, "until I decide what to do with you. And you're going to stop talking. And you're going to stop." The door opened. Officer Dana Pruitt stood in the doorway. She had a form in her hand, something from the front desk. and she had clearly not been expecting what she was looking at, because she stopped completely, and her face went through 3 distinct configurations in about 1 second. Colton released Marcus, and he stepped back. He straightened. "Pruitt." His voice was controlled again. "What do you want?" Pruitt held up the form. "Desk asked me to. The processing form for the Carver vehicle needs a signature." "Later." They said. I said later. Pruitt's eyes moved from Colton to Marcus. Marcus was sitting in the chair. His collar was twisted. His jaw was set. He was looking directly at Pruitt, not at Colton. She held his gaze for 3 seconds. Then she looked at Colton, and then down at the form, and then she left. The door closed behind her. But it did not close all the way. The latch did not catch. And there was a small gap, perhaps an inch, along the frame. In the hallway beyond the gap, the camera in corridor B maintained its indicator light. Green. Naomi and Marcus were released at 17:22. No charges. No filing. None of Naomi's bag was returned to her with the contents inventoried on a printed receipt. Every item listed, which told her that at some point during the afternoon, they had opened it and gone through it completely. The notebook was not listed. It had been on her person. They walked out of the station into the late afternoon light. The heat had shifted. Less flat now, more golden. That particular quality of late afternoon Alabama sun that made everything look faintly historical. Marcus unlocked the Range Rover. It had been moved from corridor 14 to the station lot. He got in. Naomi got in the passenger side. Neither of them spoke for a moment. Then Marcus said, "The bag." "Searched. Fully inventoried." "Find anything?" "They listed everything, which means they opened everything." She looked at the receipt. "Every item." And they're wondering who I am." She folded the receipt carefully and put it in her notebook. "They don't know, but they're wondering." Marcus put the key in the ignition. He did not start the car. "The camera in the corridor," he said. "B corridor. Indicator was green when I walked past it at 14:41. Green when I walked out at 15:30. Green when Pruitt walked past it on her way to your room." Marcus looked at her. "Pruitt's room," he started. "She left the door open," Naomi said. A silence. "An inch," he said. "An inch is enough." Marcus started the car. He put it in gear. He was about to pull out of the lot when Naomi put her hand on the dash, a small gesture, stopping him without touching him. She was looking at the bulletin board near the entrance, the one with the notices, or the one she had read through the window on the way in. At the bottom of the community policing notice, half hidden by the edge of the board mounting, was a smaller card. Recent. Printed on department letterhead. Corridor 14, Traffic Enforcement Initiative. Month 18, results attached. Deputy Chief H.P. Marcus looked at her. "Is that the email?" she said quietly. "The one we don't have yet." She took out her phone. She photographed the board through the windshield. "Who is H.P.?" Marcus said. Naomi looked at the Pierce Law billboard on the corner of Main, catching the last of the afternoon light. "I have a guess," she said. "But guesses don't hold in a hearing." She put the phone in her bag. "Drive," she said. "We're going to need to file before tomorrow morning." Marcus pulled out of the lot and onto Main Street, and the station got smaller in the mirror. The billboard got larger as they approached it. Harlan Pierce in a three-quarter pose, silver-haired, promising results. The H and the P were very large on the signage. "Tomorrow morning," Marcus said. "Filing where?" Naomi looked at the road ahead, the flat stretch of it. The heat had nearly broken. In 6 hours, she would be on a secure phone she had not used today, calling a number she knew by memory, in a building whose address was not in any county directory. Internal affairs, she said, and then one more place. Marcus waited. She said nothing else. The Range Rover moved through the last light of the afternoon, out of Millhaven, back onto the federal corridor, the same road, the same asphalt, the same mile markers counting down from 14. At mile marker 9, exactly where the enforcement zone ended, Naomi looked back over her shoulder. Nothing behind them. No lights. No cruiser. She turned forward. In her bag, beneath the notebook and the receipt and the folded document she had not signed, was a second notebook. Smaller, older, with a cover that had been reinforced at the corners with black tape. She had not opened it today. She had not needed to. The first page of that notebook, in her own handwriting, said, "Case file. Pre-existing. Do not open in field." Below that, a case number. Below that, a date, 8 months ago. Below that, a single line. Millhaven County, Corridor 14. Pattern or practice suspected. Authorization, pending confirmation. She zipped the bag closed. The road opened up ahead of them, wide and straight, heading north. And Naomi Voss-Carver looked at it the way she looked at everything. Complete. Thorough. Without needing to look again. Somewhere in the station behind them, in the evidence locker where seized property was held pending disposition, Naomi's bag had been processed and returned. But the inventory receipt had been printed by a desk computer, a computer connected to the department server, and the print job had been logged automatically with a user ID, a timestamp, and a destination printer. The log was still there. The log would still be there in the morning. And in 6 days, when the FOIA request arrived, properly filed, properly formatted, citing 5 U.S.C. Section 552, the log would show something that no one in the department had thought to delete, because no one in the department knew yet who had been sitting in that holding room, and not who she really was, not what the second notebook meant, not what came next. Naomi filed the internal affairs complaint at 6:47 the following morning. She did it from the parking lot of a gas station 12 miles north of Millhaven, sitting in the passenger seat of the Range Rover with her laptop open on her knees and a coffee going cold in the cup holder. The complaint form was a standard IA-1 document. Millhaven County Police Department, available as a PDF on the department's public-facing website, which itself was a small irony she noted without dwelling on. She filled it out in 11 minutes. She was thorough. Complainant, Naomi Voss-Carver. Date of incident, the previous day. Officers involved: Deputy Reed Colton, Badge 1147, Sergeant Nora Becht, Captain Delia Marsh. Nature of complaint: unlawful vehicle stop without documented probable cause. Unauthorized seizure of personal property without warrant or consent. Physical contact resulting in injury during property seizure. Denial of telephone access for approximately 1 hour and 40 minutes. Detention without charge for 3 hours and 41 minutes. Under supporting documentation, she typed, "Available upon request." Contemporaneous notes, photographs, and time-stamped records maintained. Physical injury documented. Additional evidence pending FOIA processing. She attached nothing. She submitted the form electronically and received an automated acknowledgement within 4 minutes. Your complaint has been received and assigned case number II-2024-0391. An investigator will contact you within 30 business days. 30 business days. 6 weeks, roughly. She wrote the case number in her notebook, the first one, the operational one, and put the laptop back in its sleeve. Marcus handed her the coffee. She drank it without complaining about the temperature. "One more place," he said. He had not forgotten. One more place. He pulled out of the parking lot, heading north. The morning was already warm, the sky the particular flat white of a southern summer day that has decided not to bother with clouds. They drove for 40 minutes without speaking, which was not uncomfortable. It was the silence of people who had known each other long enough to have sorted out which silences were fine and which ones weren't. At the junction of I-65, Naomi picked up her phone and made a call. She held it to her ear and waited through 2 rings. "It's me," she said, when the line connected. A pause. "Sir Millhaven, yes, yesterday." Another pause. Longer. "Corridor 14. 18 months of it, based on what I saw." She looked out the window at the highway, merging into the interstate. "I'll have the formal report filed within 72 hours. But I wanted you to know the stop happened to me personally." A pause. "That's not relevant. What's relevant is I now have standing as a direct victim." She paused again. "No, we're fine. Drive safe." She hung up. She put the phone in her bag. Marcus glanced at her. He said nothing. She said nothing. The interstate carried them north. The Millhaven got smaller behind them, and the billboard for Harlan Pierce personal injury law disappeared in the distance the way things do when you are moving away from them with intention. The first thing the Millhaven Police Department did was nothing. This was not unusual. Institutions do nothing first. It is their natural posture, the baseline condition of any system that has learned that waiting costs less than acting. 30 business days is a long time. And in that time, things can be clarified, contextualized, or quietly buried under the procedural sediment that accumulates around any formal complaint. Captain Delia Marsh received a copy of the IA complaint on the 2nd day. She read it standing at her desk, in the particular posture of someone reading something they expected and are nonetheless unhappy to see confirmed. Then she sat down and called 2 people. The first call lasted 4 minutes. The second call lasted 11. After the second call, she opened her desk drawer and retrieved a yellow legal pad and wrote 3 words on it, then drew a box around them, then drew another box around that. She tore the page off, folded it once, and put it in her jacket pocket. No one knew what the 3 words were. No one would know for some time. Colton, meanwhile, had been placed on what the department memo described as administrative reassignment pending review of the incident report. This was not a suspension. This was not paid leave. This was a relabeling. Colton was now assigned to the equipment room, inventorying traffic cones and breathalyzer calibration records, which was the department's way of moving a problem out of public sight while retaining the option to move it back. He was not happy about this. He expressed his unhappiness to Becht, who expressed nothing in return, and then to Frank at the dispatch desk, who said, I know the way people say it when they mean, please stop talking to me about this." Becht filed her supplemental incident report on day 3. It was 4 paragraphs. It described the stop as routine investigative detention based on Officer Colton's articulable, reasonable suspicion. It noted that no contraband was found. It noted that the complainant had declined to cooperate with standard processing procedures. It noted that the body camera malfunction had been logged and referred to the equipment maintenance unit. Becht was a careful writer. The equipment maintenance log, when it was later requested, would show that body camera Unit 7 had been submitted for maintenance on the morning after the incident. The technician's note said, "Unit found in normal working condition. No defect detected. Returned to service." Nobody at the department appeared to notice the contradiction. Or if they noticed, they elected not to write it down. On day 11, Naomi received the acknowledgement letter she had predicted. She filed it in the folder she had labeled IA-2024-0391 and moved on. On day 14, the FOIA request she had submitted, filed the morning after the stop, citing 5 U.S.C. Section 552 and its Alabama state equivalent under Alabama Code, Section 36-12-40, generated its first response, not the documents themselves. A response informing her that her request had been received and that the department had 20 business days to comply, and that an extension of an additional 20 days might be required due to the volume and sensitivity of the requested records. She had requested all incident reports filed by Officer Colton in the preceding 18 months, on all body camera activation logs for that period, all internal communications referencing Corridor 14 enforcement, and the financial records of any settlement agreements entered into by the county in connection with traffic stops on that route. The department would claim later that this was a broad request. This was accurate. It was designed to be. 3 weeks after the incident, Marcus drove back through Millhaven alone. He did not go to the police station. He went to the diner on Main Street, the one whose sign had been dark when they passed through, and found that it was, in fact, open on weekday mornings and served coffee that was better than its exterior suggested. He sat at the counter and drank coffee and talked to the owner, a woman named Bernadette, who had lived in Millhaven for 60 years and had opinions about all of them. He did not ask about the police directly. He asked about the billboard. Bernadette's expression when he mentioned the billboard was the expression of someone who has swallowed something sour so many times they no longer react visibly. "Pierce," she said. The word contained a complete sentence. "Local attorney?" "Local something." She refilled his coffee without being asked. "He's been here 15 years. Set up shop right when they started doing those corridor stops. Funny timing." She set the pot down. "You know how many people I've seen come in here after getting pulled over on that stretch? Out-of-towners mostly. Nice cars. They come in here and they're shaking, some of them. Been in that station half the day." She wiped the counter with a cloth that didn't need wiping. "And then, a week later, they get a card, in the mail, from Harlan Pierce, saying he can help them file a claim against the county. He's even got a runner, young guy, shows up at the station sometimes, who hands people his card when they're waiting in the lot." Marcus set down his coffee. "The county settles these claims?" Bernadette looked at him. "Every time. Quietly. And Pierce takes his 30%, and the officer who did the stop gets a consulting payment from Pierce's firm 6 weeks later. Everybody knows." She said this last part with the particular exhaustion of someone reporting a fact that has been known too long to be outrage. "Nobody does anything." Marcus thanked her. He left $20 for a $4 coffee. He called Naomi from the parking lot. She said, "Write it down." He said, "Already did." She said, "Bernadette, full name if she'll give it." "She will. She's been waiting for someone to ask." The FOIA documents arrived on day 37, partially. Naomi sat at the desk in her apartment in Atlanta and worked through them over the course of 6 hours, which would have been 3 hours for most people. But she read legal documents the way she read everything else, completely once and then again at the critical passages. What she received: 847 pages. What had been requested: an estimated 2,000 to 3,000 pages, based on the scope of the request. What she had was a partial response, redacted in places. Under with a cover letter noting that certain documents were exempt from disclosure under Alabama Code. Section 36-12-40 E1, as they constitute records of ongoing law enforcement investigation. The ongoing investigation referenced, insofar as she could determine, was the investigation of her own complaint. The department was using the existence of its own investigation to block her access to evidence relevant to that investigation. She noted this. She did not find it surprising. She found it instructive. She worked through the 847 pages. Incident reports, Colton. 94 stops in 18 months on Corridor 14 alone. 61 of those stops involved out-of-state plates. 53 involved vehicles valued above $40,000 per Kelley Blue Book estimate, which someone had apparently included in the initial stop documentation for reasons that were not explained. 47 of the 61 out-of-state stops involved black drivers or passengers as the primary contact, a figure visible in the demographic data included in the department's own community policing compliance reports. No contraband found in any of the 94 stops. No charges filed in any of the 94 stops. 11 complaints filed with IA over 18 months. 10 acknowledged. 9 marked closed, insufficient evidence. 1, hers, marked pending. Body camera activation logs, gaps in 23 of 94 stops. Logged reasons, equipment malfunction, 17 times. Unit not charged, 4 times. Activation delay, twice. No disciplinary action noted for any gap. Settlement records, redacted, on all financial figures blacked out. The county had apparently entered into agreements with 12 individuals over the 18-month period. The agreements themselves were not provided. The existence of them was visible in the settlement register. But every dollar amount and every NDA clause had been rendered unreadable. Naomi reached for a red pen. She began marking the document in the margins with the particular precision of someone who already knew what she was looking for and was now confirming it existed. The email she was looking for was on page 612. It had been partially redacted. The sender line showed H. Pierce followed by a domain that had been blacked out. The recipient line showed D. Marsh followed by the same blackout. The subject line, Corridor 14, monthly numbers. The date, 6 weeks before the incident. The body of the email, Delia. Remind the boys the stretch between mile marker 9 and 14 is our best yield. Out-of-state plates, nice cars. They don't know the local judge. The last 3 settled at the rate we discussed. RC gets his payment Friday. Keep the camera logs clean. The gap pattern from last fall almost caused a problem. Tell him to vary the reasons. HP. Below that, 1 more line. Heavily redacted. Only 3 words visible at the beginning and 4 at the end. If the redacted. Redacted, redacted. 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 We need to adjust the redacted before redacted gets involved. She looked at the 3 visible words at the beginning. She looked at the 4 visible words at the end. She turned to page 613. On page 613, there was a second email. Same thread. Reply from Marsh. Understood. I'll handle RC. On the camera thing. Noted. DM. And below that, a single line forward notation. Forwarded from Marsh's account to a 3rd address. The address, completely redacted. The forwarding note, FYI. She might want to know about this in case it becomes a thing. Naomi circled the word she in red. She sat for a moment. Then she turned to the next page. On day 42, Naomi received a phone call from an IA investigator named Gaines. Leonard Gaines, a tired-sounding man in his late 50s who had the particular vocal quality of someone who had been doing a job long enough to have stopped being surprised by it. He asked her to describe the incident. She did. He asked follow-up questions that were procedurally thorough, if not especially energetic. He asked whether she had witnesses. She said her brother. He asked whether she had documentation. She said yes. He asked whether she could provide it. She said she would send it within 24 hours. She sent it within 6. 412 pages. Contemporaneous notes. Photographs of her cheekbone taken at 4 different time intervals over the 48 hours following the incident. The settlement she had refused to sign, photographed through the holding room table. She had held it at an angle and used her phone camera to capture the text before Pierce put it away. The gap in Colton's body camera log, cross-referenced with the maintenance record showing the unit found in normal working condition. The email from page 612. Gaines called back 2 days later. His voice had a different quality this time. Not surprised, but different. "Ms. Voss-Carver," he said, "I want to be transparent with you about something. I've forwarded your documentation to the department's legal division for review. That is standard procedure. It doesn't mean—" "How long does review take?" she asked. "Typically 2 to 4 weeks. And then?" "And then I receive a recommendation from legal, and I incorporate it into my investigation findings." A pause. "I want to be straightforward. The scope of what you've submitted goes beyond the individual stop. If what you're describing is accurate, it's documented. If the documentation supports the scope of what you're describing," he continued carefully, "this would likely move beyond a standard IA complaint." "To what?" "That's what review will determine." Another pause. "Ms. Voss-Carver, are you planning to remain available over the next several weeks?" "I am," she said. "Good." He hung up. She wrote in her notebook, "Day 42, Gaines, Leonard, Iowa. Voice different, escalating, forwarded to legal, expected timeline, 2 to 4 weeks additional." Below that she wrote, "He said she might want to know. Third address, unknown." Below that she wrote, "Find her." The FOIA appeal arrived 3 days later, Naomi's appeal of the partial response, formally filed with the Alabama Attorney General's Office under Alabama Code, Section 36-12-41. She had anticipated the 37-day partial response. She had filed the appeal the same afternoon she received the documents. The appeal argued that the ongoing investigation exemption was being applied improperly to block evidence relevant to a pattern of conduct rather than to protect the integrity of a specific investigation. The AG's office acknowledged receipt in 9 days. Naomi noted the response time. It was faster than she had expected. She noted that too. Marcus brought Bernadette to Atlanta. Not physically. He brought her in the form of a recorded statement, taken with Bernadette's full knowledge and consent, on a phone positioned on the diner counter while they talked. 43 minutes. Bernadette spoke with the unhurried clarity of someone who had organized her observations over 60 years and found them easy to retrieve. She described Pierce's runner. She described the pattern of out-of-town stops. She described 6 specific instances. She had dates, partial plate numbers in some cases, first names of people who had sat at her counter afterward. She described the settlement cards. She described having once asked a departing customer whether they'd reported the stop. Mahart and the customer, a man from Nashville passing through, had said Pierce's office had called them before they even got home, and they had signed something to make it stop. Before they even got home. Naomi listened to the recording twice. She wrote, "Bernadette. Contemporaneous knowledge, 60-plus years residency. 6 documented incidents, partial corroboration. Pierce contact prior to complainant reaching home state. Implies advance notice from department." She underlined advance notice from department. On day 58, Reed Colton made a mistake. It was a small mistake in the way that small mistakes are the ones that open everything. Colton, still assigned to the equipment room, had taken to eating his lunch in the parking lot of a gas station 3 blocks from the station. A habit of small rebellion, a way of being outside the building without technically being absent. On day 58, a reporter from the Mill Haven Courier sat down in the car next to his and introduced herself. Her name was Tessa Moreau. She was 26 and had been covering Mill Haven County for the Courier for 2 years and had heard about the FOIA request through the Public Records Office clerk, who had mentioned it to someone who had mentioned it to her. She was not an investigative journalist in any formal sense. She was a local reporter with a notebook and the particular advantage of being underestimated. She asked Colton about the stop. Colton, in the parking lot, having lunch, away from the station and therefore feeling incorrectly that he was also away from consequences, said several things. He said, those people had no reason to be on that road. And he said, out of state means out of jurisdiction, which means they don't know how things work here. He said, my body camera malfunctions all the time. It's old equipment. I've been saying that for 2 years. He said, Pierce just does what Pierce does. I don't have anything to do with that. Tessa Moreau wrote it all down. She recorded it on her phone, which was in her jacket pocket, and which she had turned on before she got out of her car. She published the piece 6 days later. It was 400 words in the Courier's print edition and slightly longer online. It was not a dramatically written piece. It was a carefully sourced, precisely worded account of the stop, Colton's comments, and the IA complaint, which was, as a filed public record, available to her. It contained one quote from Pierce's office. No comment at this time. And it contained one quote from the department's public affairs liaison. We do not comment on pending IA matters. The Courier had 1,200 subscribers. The Associated Press picked up the story in 48 hours. In 72 hours, it had appeared in 4 regional papers and 2 national wire services. In 96 hours, the Alabama Attorney General's office called Gaines's office. Naomi found out through a text from a number she did not save in her phone. The text said, a G office contacted IIR Mill Haven, Monday morning. You have friends in the right places. She stared at the text for a moment. She wrote in her notebook, day 64, a G contacted IA, unknown source, 3rd address. She. Cross-reference. She knew who it was. She was not ready to write it down yet. Day 71. That the Internal Affairs disciplinary hearing was scheduled for a building in Montgomery, neutral ground, insisted upon by Naomi's newly retained attorney, a woman named Clara Osei, who worked out of a firm in Birmingham and whose particular specialty was civil rights cases against municipal law enforcement. Osei was not a dramatic woman. She was methodical in the particular way of someone who had learned that drama worked against you in administrative proceedings and had adjusted accordingly. Osei had called Naomi 3 days after the Courier piece. You filed this yourself, Osei said, reviewing the complaint paperwork during their first call. Yes. Without representation. Initially, yes. A brief pause. The documentation is thorough. I try to be. You realize what you have in the email. I know what I have. You realize the FOIA appeal is well constructed. The exemption application is legally flawed. They're using 36-1240E1 to block records that are not operationally sensitive by any reasonable reading of the statute. I know. Another pause. Miss Voss-Carver, I've been doing this for 17 years. People don't usually submit 400 pages of contemporaneous documentation on their own. They don't usually cross-reference body camera logs against maintenance records on their own. They don't usually recognize the legal vulnerability of a mutual release clause they haven't signed. She paused. What do you do? Documentation work, Naomi said. Osei was quiet for 2 seconds, and then she said, Are you prepared for the hearing? I've been prepared since day one. Then let's talk about what we're walking into. The hearing was scheduled for a Tuesday. It was an internal affairs disciplinary hearing under the procedures established by the Millhaven County Police Department's own policy manual, Section 7, Articles 14 through 22. Procedures that, when read carefully, required the presence of an independent hearing officer, the submission of evidence by both parties, the right to cross-examination of witnesses, and the right to call witnesses. Naomi arrived 40 minutes early. Osei arrived 35 minutes early. They sat in the corridor outside the hearing room, and Naomi reviewed her notes for the last time, not because she needed to, but because the act of reviewing was itself a form of preparation, of moving through the known territory one more time before entering the uncertain one. The hearing panel consisted of 3 people: the independent hearing officer, a retired judge named Harmon who had been appointed by the county, a representative from the county's Human Resources Division, and a representative from the Police Officers Association. The union, in other words, which meant that one of the 3 people on the panel had an institutional interest in the outcome that was not aligned with Naomi's. This was normal. She had accounted for it. On the other side of the table, Colton, in a suit that did not fit the same way his uniform did. Beside him, his union attorney, a man named Finster, who had the confident, slightly bored demeanor of someone who spent his professional life in rooms like this and had a settled win rate. Becht, in uniform. Marsh, also in uniform, sitting slightly apart from the others in a way that communicated a distinction she was hoping someone would notice. Pierce was not present. Pierce had not been subpoenaed for the IA hearing. IA hearings do not have subpoena power over private citizens. That was a problem for a different proceeding. Hearing Officer Harmon called the session to order at 9:03 and read through the administrative preamble with the efficient dryness of a man who had read it many times before. He outlined the purpose of the hearing: to review the complaint filed under IA 2024-0391 and determine whether departmental policy violations had occurred, and reminded all parties that this was an administrative proceeding, not a criminal one, and that different evidentiary standards applied. Finster opened for Colton with a prepared statement that described the stop as consistent with established patrol procedures on a high-yield enforcement corridor, that characterized Colton's articulable suspicion as documented in his incident report, and that described the incident with the bag as an inadvertent contact during a lawful evidence-securing procedure. He used the phrase professional judgment 4 times in 11 minutes. Osei's opening was 2 minutes long. She said, "We will present documentation showing that the stop lacked articulable probable cause, that the body camera was deactivated during the period of the stop, that a pattern of identical stops exists across 18 months on this corridor, that a financial arrangement exists between the arresting officer and a private attorney who profits from these stops, and that my client sustained physical injury during an unlawful seizure of her property. We will let the documentation speak." She sat down. Hearing Officer Harmon looked at her over his glasses. Then he looked at Finster. Then he said, "Let's begin." The evidence presentation took most of the morning. Osei submitted each item with a brief authentication statement. Not elaborate, not theatrical, just the factual scaffolding required to establish admissibility in an administrative proceeding. The body camera activation log. Body camera Unit 7, serial number BC1147ML. Downloaded from the Millhaven PD Department server on the 3rd day following the incident by IT specialist D. Wren, under Chain of Custody Log Reference COC-2024-0391-A. Deactivation at 14:09. Reactivation not logged. Stop documented 14:06 through 14:19. gap of 13 minutes and 0 seconds. The maintenance record, equipment maintenance log, Millhaven PD, submitted by Officer Colton following the incident. Technician notation. Unit found in normal working condition, no defect detected, returned to service. Date of submission, the morning following the incident. Colton's incident report. Filed 22/14 on the date of the incident. Articulable suspicion documented as potential tint violation, observable behavioral indicators. Behavioral indicators not specified. No tint measurement taken. No measurement instrument deployed. The 47 stop demographic data. Submitted as a summary drawn from Colton's own incident reports. Osei read the numbers without comment. The email. Partial FOIA disclosure. Page 612 of 847. Email from H. Pierce to D. Marsh. Date established. Body text read in full. She read it. The room was very quiet when she finished. Harmon wrote something on the legal pad in front of him. The settlement register. 12 settlements in 18 months. Financial figures redacted by department. Existence of settlements not disputed. Settlement agreements require FOIA appeal ruling for full disclosure. Appeal pending before the Alabama AG's office. And then she submitted the maintenance log cross-reference, which showed that Colton had submitted body camera unit 7 for maintenance 11 times over 3 years, and that in 10 of those 11 submissions, the unit had been returned with a notation of no defect found, and that in 9 of those 10 instances, the submission had followed a stop in which the activation log showed a gap. 9 times. Not once. 9 times. Finster objected to the relevance of the prior submissions. Harmon considered it for 4 seconds and said, "I'll allow it. Pattern evidence is germane." He wrote something else. The union representative had been quiet for most of the morning. He spoke once to note that Officer Colton had served the department for 19 years with no formal disciplinary record. And Osei said, "The absence of a formal record and the absence of misconduct are not the same thing, as the maintenance log cross-reference demonstrates." Harmon said, "Noted." Dana Pruitt testified at 11:42. She came in uniform. She sat at the witness table and folded her hands in front of her, and looked at hearing officer Harmon and answered questions with the careful precision of someone who had rehearsed this, not to perform it, but to make sure she said the truth correctly. Osei asked, "Officer Pruitt, on the afternoon in question, you went to the processing room where Mr. Marcus Carver was being held. What did you observe when you entered that room?" Pruitt said, "Officer Colton had Mr. Carver by the collar. He had pulled him partially out of the chair." "What did Officer Colton do when you entered?" "He released Mr. Carver, or he stepped back." "How would you characterize the physical contact you observed?" Pruitt was quiet for a moment. "It was not consistent with standard detainee management procedure. Mr. Carver was not resisting. He was seated." "What did you do?" "I delivered the processing form I had been sent to deliver, and I left." "Did you close the door behind you?" A brief pause. "Not completely." "Why not?" Pruitt looked at her hands. "I thought it was important that what was happening in that room be visible." "To the camera in corridor B?" "Yes." Finster objected. "Speculation about the witness's intent," Harmon said. "She's testifying to her own intent. Overruled." Osei said, "Officer Pruitt, the camera in corridor B, was it operational at the time of your visit to the processing room?" "Yes." "How do you know?" "Because I checked the indicator before I walked past it. I made a point of checking it." A silence. "Why?" Osei asked. Pruitt looked up from her hands. She looked at Hearing Officer Harmon. "Because I knew the footage might matter," she said. "And I wanted to make sure someone was recording." Finster began another objection. Harmon held up a hand without looking at him. "Continue." The hearing broke for lunch at 12:30. In the corridor, Osei handed Naomi a bottle of water and a granola bar and said, "Harmon's writing more than he needs to write if he's going to find insufficient evidence." "I know." "The email changes the character of this. It's not a rogue officer anymore. And it's a pattern with financial incentive and supervisory awareness." "I know." Osei looked at her. They had worked together for 9 weeks, and in that time Osei had developed a particular curiosity about Naomi. Not invasive, professional. The curiosity of someone trying to calibrate a client. "You've been very measured throughout this," Osei said. "Most people, even people with strong cases, show something: anger, nerves, satisfaction when something lands." She paused. "You just noted." Naomi looked at the corridor wall. "Showing it doesn't help the record." "No," Osei said. "It doesn't." A pause. "Who called you?" Naomi looked at her. "Someone tipped you that the AG contacted IA," Osei said. "Unknown number. You mentioned it when we were preparing. Someone inside this process is aligned with your outcome." She said it clinically, without implication. "I'm not asking for a name. I'm asking so I know what I can rely on." Naomi considered the question for a moment. "Someone who knew what Corridor 14 was before I got stopped on it," she said. "Someone who was waiting for a complainant who could follow through." Osei absorbed this. "How long has Corridor 14 been on a watch list?" 8 months, Naomi said. "Maybe more." Osei nodded slowly. She did not ask the next question. She was smart enough to know which questions to stop at. She said, "Afternoon session starts at 2. Marsh testifies." Delia Marsh testified for 40 minutes and said very little. Not because she was evasive in the clumsy way, not stonewalling, not contradicting herself dramatically, but because she was precise in the way of someone who had been coached carefully and had followed the coaching well. She confirmed facts that were already documented. She disputed characterizations. She used the phrase, to my knowledge, 14 times, which Naomi tracked in the margin of her notes. When Osei asked about the email, Marsh said, "I received a communication from Mr. Pierce referencing corridor enforcement priorities, and I understood it as a reference to the legitimate enforcement objectives of the initiative." "You understood they don't know the local judge as a legitimate enforcement objective?" "I understood the communication in its overall context." "And the phrase, 'keep the camera logs clean,' how did you understand that in its overall context?" "I understood it as a reference to proper equipment maintenance." "Camera logs are not equipment maintenance records." "I understood it as a general reference to operational compliance." Osei looked at her for a moment. Then she said, "Captain Marsh, did you forward this email to a third party?" A pause, brief, controlled. "I forward many communications in my normal duties. Did you forward this email?" "The one on page 612 of the FOIA disclosure?" "I don't have a specific recollection." "The forwarding notation is on page 613. It shows your account forwarded it to a redacted address. Do you recall to whom you forwarded it?" Marsh said, "I'd need to review my records." The address is redacted in the FOIA response. Do you know why it was redacted? Finster, representing the department's institutional interests, now rather than Colton specifically, said, "Objection. The witness is not the custodian of FOIA redaction decisions." Harmon said, Sustained. Rephrase. Osei said, "Do you know who the third address belongs to?" Marsh said, "I'd need to review my records." She said this in the same tone she had used for the previous 15 answers. Osei let it sit for 3 seconds, which was enough. "Nothing further," Osei said. At 3:44, Harmon called a recess and asked both parties to submit any final documents before close of business the following day. He said that findings would be issued within 15 business days. 15 business days, 3 weeks. In the corridor afterward, Finster spoke to Colton in a low voice near the elevator. Colton's face had been doing something complicated for the last 2 hours. The confidence that had animated it on Corridor 14 had processed through several intermediate states and arrived somewhere that was not quite recognition and not quite fear, but had elements of both. He looked up once, across the corridor, and found Naomi looking back at him. She was not looking at him with anger. She was not looking at him with satisfaction. She was looking at him the way she looked at everything. Complete. Thorough. And he looked away first. The DA's office made contact 12 days after the hearing. A representative, an assistant district attorney named Walcott from the Northern District of Alabama, called Osei's office and requested a meeting. Osei called Naomi. Naomi said, "When?" "Day after tomorrow. I'll be there." The meeting was in Birmingham, in a conference room with fluorescent lights and a window that looked onto a parking structure. Walcott was in his mid-40s, careful with the unhurried deliberateness of someone who moved slowly, because moving slowly was how you didn't make errors you couldn't undo. He said, "The IA findings haven't been issued yet. I want to be clear that we are not acting on those findings. We are acting on the referral we received from the AG's office following their review of the FOIA appeal." Naomi said, "The appeal hasn't been ruled on yet." "No, but the AG's office reviewed the underlying materials as part of their appeal assessment, and they referred the matter to us under 18 U.S.C. Section 242. He opened a folder. Specifically, the financial nexus between Officer Colton's enforcement activities and Mr. Pierce's settlement scheme raises potential conspiracy charges under 18 U.S.C. Section 241 as well. He paused. "I want to explain what that means for the timeline." "Please," Osei said. "It means this is no longer purely an administrative matter. The department can handle its disciplinary proceedings on its own schedule. The criminal question is separate, and criminal investigations take time." "How much time?" "Months, at minimum. Potentially longer. We have to establish the financial nexus through records that are currently redacted, which means we need a separate subpoena process, which means court filings, which means responses and objections." He closed the folder. "I'm not here to give you a timeline. I'm here to tell you that this office has opened a criminal inquiry and that we will be in contact." Naomi said, "Harlan Pierce?" Walcott looked at her. "The email identifies Pierce as the initiating party. The scheme requires his active participation. The runner at the station, the advance notice to victims before they leave Alabama. He's not peripheral." "I understand. Is he being investigated?" Walcott looked at his folder. "We are examining all parties whose conduct is reflected in the available documentation." Naomi said, "The third address in the forwarding notation. Marsh forwarded the email to someone. That person has not been identified. That person was described in the email thread as needing to know in case it becomes a thing." Walcott was quiet for a moment. "You're suggesting the scheme extends beyond Pierce and Colton." "I'm noting that the email suggests it does, and that the third address was redacted in the FOIA response, which means either the department redacted it or someone with authority over the FOIA process did. Walcott wrote something. He wrote slowly, deliberately. He said, "We'll be in contact, Ms. Voss-Carver." The IA findings came on a Thursday morning, 15 business days after the hearing, exactly as Harmon had said. An OSE sent them by email with a brief note. "Read pages 1 through 4, then call me." Naomi read all 18 pages first. Then she called. Findings of the Internal Affairs Disciplinary Hearing, IA-2024-0391, as to Officer Reed Colton. The panel finds, by a preponderance of evidence, that Officer Colton initiated a vehicle stop on Corridor 14 without adequate documented probable cause consistent with Alabama Rules of Criminal Procedure. Rule 3.1. The panel further finds that the pattern of body camera activation gaps, cross-referenced with maintenance records showing no equipment defect, raises a significant credibility concern regarding the equipment malfunction explanation. The panel further finds that the physical contact during property seizure was not consistent with departmental use of force policy for a cooperative, non-threatening subject. Determination. Officer Colton is hereby suspended without pay, pending further review. The matter has been referred to the District Attorney's Office. As to Sergeant Nora Becht, the panel finds that Sergeant Becht's supplemental incident report characterized the complainant's conduct in a manner inconsistent with the documented record. The panel further finds that Becht's supervision of the stop did not include an adequate independent assessment of probable cause before ordering continued detention. Determination, written reprimand, mandatory retraining in constitutional stop procedures. As to Captain Delia Marsh, the panel finds that the email identified in the FOIA disclosure, combined with the forwarding notation and the settlement register, raises questions about supervisory complicity in a pattern of conduct that warrants further investigation. The panel notes that the financial nexus documented between departmental enforcement activity and private legal representation constitutes a serious concern that exceeds the scope of this administrative hearing. Determination. Captain Marsh is placed on administrative leave with pay pending completion of the ongoing criminal inquiry. This panel does not make a final disciplinary determination pending that inquiry's outcome. Additional findings. The panel recommends that the City Council of Millhaven County commission an independent audit of Corridor 14 enforcement activities covering the preceding 24 months, including financial review of settlement agreements, body camera compliance, and demographic enforcement patterns. This audit should be completed by an independent entity with no current or prior relationship with the department or Mr. Pierce's law firm. The panel further recommends that all future stops on Corridor 14 be subject to mandatory body camera activation with no deactivation permitted during the stop. Violation to result in automatic disciplinary review. Naomi closed the email. She sat for a moment. Then she called OSE. "The Marsh determination is qualified," Naomi said. "Pending the criminal inquiry?" "Yes." "Which could take a year. At least. And Pierce isn't in the findings at all. He's civilian." "Correct. The criminal referral is the only avenue. Colton's suspended but not terminated. Suspension without pay pending review. If the criminal case develops and there's a conviction, or if the criminal inquiry produces additional misconduct findings, termination follows. But the union will fight termination procedurally for as long as they can." OSE paused. "Naomi, this is a strong outcome for an administrative proceeding. Suspension, written reprimand, administrative leave, independent audit, mandatory body camera policy. Most IA complaints are closed with nothing." Naomi knew this. She had known this before she filed. The third address, she said. Still unknown. The redacted financial figures in the settlements. FOIA appeal still pending. The 10 minutes and 13 seconds. Osei said, the IA findings note the credibility concern. They don't resolve the 10 minutes. Nobody knows what happened in those 10 minutes and 13 seconds. The camera wasn't running. Naomi looked at the window of her apartment. The Atlanta skyline was doing its late afternoon thing. The light hitting the glass towers at an angle that made them look briefly warmer than they were. What happens now? She said. Criminal inquiry proceeds on its own schedule. Council commissions the audit. They'll vote on it at the next public session, which is in 3 weeks. Pierce waits to see how exposed he is. Marsh waits. Colton waits. Osei paused. And we wait. I'm not good at waiting. I know. But you've built something here. The IA findings, the criminal referral, the FOIA appeal, the audit recommendation, these are layers. They don't come apart easily. You've built something that persists even if you're not in the room. Naomi was quiet for a moment, and then she said, the City Council public session, 3 weeks. Yes. I want to be there. I expected that. I'll make sure we're on the agenda. The Millhaven City Council met on a Wednesday evening in a chamber that held 80 people and had approximately 120 in it when Naomi and Marcus walked in. Tessa Moreau from the Courier was there. 2 reporters from Birmingham papers were there. A local TV crew had set up in the back. Bernadette from the diner was in the 3rd row, dressed in her good clothes, sitting with 3 other women Naomi did not recognize. Councilman Ted Wiley was at the dais with the other 6 council members. He was a large man with an expensive haircut and the manner of someone who had been important in a small place for a long time and had made the mistake of confusing those 2 things. He called the session to order and moved through the early agenda items with the practiced efficiency of someone trying to get to the hard thing at a speed that felt controlled. The IA findings were agenda item 4. Wiley introduced them. We are here to receive the findings of the Internal Affairs hearing in the matter of IA-2024-0391 and to consider the panel's recommendations regarding departmental policy and an independent audit. He paused. I want to note for the record that this department has 20 years of service to this community. The actions of one officer, a woman in the 2nd row said clearly and without raising her voice, 3 officers. The chamber was quiet. Wiley looked for the speaker. He found her, a woman in her 70s with gray locks and reading glasses on a chain around her neck. He recognized her. Most of the room recognized her. She had been coming to council meetings for 30 years. The findings, Wiley said, moving on, reflect the panel's independent assessment. The council's role tonight is to vote on the audit recommendation and the body camera policy amendment. Naomi was at the public comment table. Osei was beside her. When public comment opened, Naomi stood. She did not use notes. She had written what she needed to say 3 days ago and had not looked at it since. Councilman Wiley, council members. She looked at each of them in turn, not as a rhetorical gesture, but because she wanted to see their faces when she spoke. My name is Naomi Voss-Carver. I am the complainant in IA-2024-0391. I was stopped on Corridor 14 without probable cause. I had personal property seized without warrant or consent. I sustained physical injury during that seizure. I was denied a phone call for 1 hour and 40 minutes. I was presented with a document designed to waive my right to file this complaint in exchange for my release. She paused for 1 second. These things happened because a system allowed them to happen, not because one officer made a mistake on a bad day. Because 18 months of documented stops, with no contraband found, with a consistent demographic pattern, with a body camera deactivated 9 times under the same false explanation, with financial payments flowing from a private attorney to the officer conducting the stops. That system did not emerge from a single bad day. She looked at Wiley. It was built. And the audit this panel has recommended will begin the process of documenting how it was built and who built it, and what it cost the people who were stopped on that road before me. She sat down. Wiley said, "Thank you for your comment." His voice was neutral in the way of someone keeping it neutral through effort. The vote on the audit commission was 5-2 in favor. The 2 dissenting votes were Wiley and a council member named Pettigrew, who had not said a word all evening. The vote on the mandatory body camera policy amendment was 6-1. Wiley voted yes. Pettigrew voted no. Naomi noted both outcomes in her notebook. Harlan Pierce did not attend the council meeting. He had not been expected to. He had, however, retained a second attorney, a firm from Mobile, and had issued a statement through that firm 2 days before the meeting. The statement said, "Mr. where Pierce categorically denies any improper relationship with any law enforcement agency. He has cooperated fully with all legitimate inquiries and will continue to do so." He had not, in fact, been asked to cooperate with anything yet. The statement was preventive. Naomi noted that too. On the Thursday following the council meeting, Walcott called Osei. He said, "We have a cooperating witness." Osei called Naomi immediately. Naomi said, "Who?" He wouldn't say on the phone, but he said the witness can speak to the financial arrangement directly, not circumstantially, directly. Naomi thought of the runner Bernadette had described, the young man who handed out Pierce's cards in the station parking lot, the one who would have known the mechanics of the system from the inside. "When?" she said. "He needs time to finalize immunity terms." Walcott said weeks, maybe a month. "Okay." "Naomi." Osei's voice had something in it that was not quite caution and not quite warmth, but occupied the space between them. "This is going somewhere. I want you to understand that where it goes may not look like what you imagined. I never imagined anything. You imagined something. Everyone does." A pause. "I imagined documented accountability," Naomi said. "Not overnight, not complete, partial, slow, and documented." "That," Osei said, "is probably what you're going to get." 6 months after the stop on Corridor 14, the Alabama AG's office issued its ruling on the FOIA appeal. The ruling: the department's application of the law enforcement investigation exemption was improperly broad. The redacted financial records from the settlement register were ordered disclosed within 30 days. The redacted third email address was ordered disclosed within 30 days, subject to any legitimate privacy protections for private individuals not under investigation. The department's counsel filed a motion for reconsideration. Standard. The AG's office denied the motion in 18 days. The financial records arrived on a Tuesday. Naomi spread them across her kitchen table and worked through them over 2 days. 12 settlements in 18 months. Total value: $462,000 paid from the county's general liability fund. Taxpayer money. Pierce's firm had received 30% of each settlement as legal fees, which was the standard contingency rate. His total, $138,600. Of that, according to invoices for consulting services paid from Pierce's firm to a sole proprietorship registered in Colton's wife's name, $41,000 over 18 months. Not a direct payment to Colton, a payment to a company in his wife's name, designed to be deniable, almost deniable. The cooperating witness, whose identity Walcott had still not disclosed, had apparently provided something that made the almost do most of the work. The third email address, when it was disclosed, belonged to a deputy chief who had retired from the Millhaven department 14 months before the incident. His name was not Pierce. His initials were not HP. He had nothing publicly visible to connect him to the scheme. His name was Harold Pierce. One letter difference. He had retired to a house in Gulf Shores. He had a pension. He had, first, according to records Naomi requested through a separate channel, been the department's liaison to the county's general liability insurer, the person who had managed the settlement process from the department's side. He had approved every one of the 12 settlements. He was not named in the IA findings. He was not mentioned in the criminal referral. He had retired quietly before the complaint was filed and was, as of the disclosure date, not under any formal investigation. His initials were in the email. His address was in the forwarding notation. He had been told to know about it in case it becomes a thing. It had become a thing. Whether that would reach him, through the criminal inquiry, through the audit, through some avenue not yet identified, that was a question that did not yet have an answer. Naomi wrote his name in her notebook. She wrote it in full, clearly, with his former title and the date of his retirement and the date of the email. Then she wrote, "Audit scope includes settlement approval chain, deputy chief level and above." She emailed that note to Osei, who emailed it to the independent auditor who had been appointed by the council 3 weeks earlier, who was a woman named Dr. Renata Solis from the University of Alabama's Public Policy Department, and who had, in Naomi's assessment of their 2 phone calls, the exact right combination of methodological rigor and institutional independence. Marcus called on a Sunday evening. Naomi was at her desk. The second notebook, the smaller one with the reinforced corners, was open in front of her to the page that said Millhaven County, Corridor 14, pattern or practice suspected, authorization, pending confirmation. Below that she had written, authorization confirmed, day 1. Below that, a dozen more entries over 6 months. Marcus said, "How are you?" She thought about it. Tired. The good kind or the other kind? Both. A pause. "I heard from Bernadette today," he said. "She said people are talking at the diner about the council vote, about the audit. She said a man came in last week from out of state, had been stopped on Corridor 14 3 years ago, had signed a release, had always felt wrong about it. He wanted to know if there was someone he could talk to." "Send him to Osei," Naomi said. "I did." A longer pause. "There's a letter for you," Marcus said. "At my address. I checked the box today, handwritten. Return address is a Millhaven P.O. box." Naomi was quiet for a moment. "Bring it when you can," she said. "You don't want to know who it's from?" "I have a guess." "Pruitt?" She did not confirm it. She looked at the notebook in front of her, at the case number, at the date, 8 months before the stop, at the line, authorization, pending confirmation. She thought about the text from the unknown number. She thought about Marcia's email saying she might want to know. She thought about the woman who had checked the camera indicator before she walked past it and left a door open an inch. "Bring the letter when you can," she said. "I'll open it when I'm ready." She was not ready yet. She needed the investigation to reach its next stage first. She needed the audit to proceed. She needed the criminal inquiry to move. She would open the letter when the shape of things had settled enough that the personal could be separated from the procedural. She did not know when that would be. The Courier piece had generated, by the 6-month mark, 11 follow-up articles. From the Courier itself, from 3 Birmingham papers, from a Montgomery outlet, and from a national civil rights organization's newsletter that reached an audience of approximately 40,000 people. Tessa Moreau had been offered a position at the Birmingham paper and had declined, which surprised people who did not understand why she would stay. She stayed because Millhaven was not finished yet. On a Thursday, that was 7 months and 4 days after the stop on Corridor 14, Naomi parked the same Range Rover. It was the same one. Marcus had kept it, which was itself a statement of something. On the shoulder of the road at mile marker 12. She got out. She stood in the heat, which was the same kind of heat it had been that afternoon. Flat iron, wet wool, unmerciful. She looked at the posted notice on the metal stake near the guardrail. It had been replaced. The old weathered card was gone. A new laminated notice was there, crisp, recent. It read, Millhaven County Police Department, Corridor 14 Notice. Pursuant to City Council Resolution 2024-47, all traffic stops on this corridor require mandatory body camera activation for the duration of the stop. Officers are required to state specific probable cause prior to initiating any detention. Citizens' rights under the Fourth Amendment are paramount to this department's mission. Below that, questions or concerns. Internal Affairs, number. Community Oversight Committee, number. The Community Oversight Committee had been established by the same council resolution. It had 3 civilian members. One of them was Bernadette. Naomi read the notice once. She took a photograph of it. She wrote the date and the time in her notebook. She got back in the car. The criminal inquiry into Pierce and Colton was ongoing. No charges had been filed yet. Walcott had said months. It had been 7. The cooperating witnesses' immunity terms had been finalized 4 weeks ago, and Walcott had said the evidentiary picture was developing in a way he found promising, which was the most optimistic language she had heard from him, and which she weighted accordingly. Marsh remained on administrative leave. Her attorney had been in contact with Walcott's office. Naomi did not know the content of those contacts. Becht had completed her mandatory retraining and had been returned to duty. Not on Corridor 14, but in the department. She had not spoken publicly about any of it. Colton was suspended. The union was contesting the suspension through its own grievance process. The grievance process had a timeline of its own. Harold Pierce was in Gulf Shores. He had not, to Naomi's knowledge, been contacted by any investigative authority. The audit was 8 weeks from its completion date. The audit scope had been expanded twice. She opened the letter on a Saturday morning, 3 weeks after Marcus brought it. The envelope was plain. The return address was the Millhaven P.O. Box. The handwriting on the front was small and deliberate. Inside, 2 pages. The handwriting continued, the same small, deliberate hand. Ms. Voss-Carver, I've started this letter 4 times. I'm not sure I'll finish it this time either, but I'm going to try. I knew about the corridor stops before that afternoon. Not the financial part. I didn't know about Pierce until the FOIA email came out. But I knew the stops were happening, and I knew they weren't right, and I didn't do anything more than carry water cups and leave a door open. I keep thinking about what you said in the holding room. You said, write that down. Not to me. You weren't talking to me. But I heard it. I wrote it down. I don't know if this letter is appropriate or useful. I'm not asking for anything. I just wanted you to know that I saw you. I saw what you did and how you did it. The notebook, the way you looked at his camera, the way you read that sign before you even stopped the car. I didn't know who you were. I still don't, not really. But I knew you weren't afraid. I hope you're well. I'm sorry I couldn't do more. D. Pruitt. Naomi read the letter once. She folded it on its original creases and put it back in the envelope and held it for a moment. Then she placed it carefully in the second notebook, the small one with the reinforced corners, between the first page and the second. Between Millhaven County, Corridor 14, pattern or practice suspected, and the case number beneath it. She closed the notebook. She sat at her desk for a while. The Atlanta morning was coming through the window, the city doing its usual thing, indifferent and continuous, the way cities are. On her desk, the FOIA documents, Osei's last email, the audit timeline, the council resolution, a printout of the Courier's most recent piece, Tessa Moreau, under her own byline, which the Birmingham paper now ran with a co-publication credit. The piece was about the Community Oversight Committee's first meeting, which had lasted 3.5 hours and covered, among other things, a proposal to commission a review of all stop and detain incidents county-wide over the preceding 5 years. Naomi wrote one thing in the operational notebook. She wrote it in the margin, in the smaller handwriting she used for observations she was still turning over. Pruitt. I knew you weren't afraid. She looked at the words for a moment. Then she wrote underneath them in the same small hand. She was wrong about that. She capped the pen. She looked at the page with the redacted email on it. Still there, still visible, in the 3 words at the beginning of the final line and the 4 at the end. If the redacted shroud, redacted, we need to adjust the redacted before redacted gets involved. Harold Pierce in Gulf Shores. His initials in the email. His address in the forwarding notation. His name in no investigation yet opened. The audit had 8 weeks. Naomi picked up her phone. She navigated to a number she had not called in 3 months. A number associated with the case file in the second notebook, the one with the date 8 months before the stop. She looked at the number for a moment. She put the phone back down. Not yet. There was an order to things. There was a procedure. The audit needed to complete. The criminal inquiry needed to reach the next evidentiary milestone. The FOIA financial records needed to be cross-referenced with Pierce's approval signatures. Things needed to be in the right sequence. She had always known there was a third address. She had always known it pointed somewhere she would need to reach carefully. The question was not whether she would reach it. The question was when. The Courier ran one more piece the following week. Tessa Moreau, byline, 1,200 words. It was about the notice at mile marker 12, the new laminated card, the council resolution, the Community Oversight Committee. It quoted Bernadette. It quoted Dr. Solis, the auditor, who said the audit was proceeding and findings would be significant. Whilst it quoted a legal scholar at the University of Alabama, who described the Corridor 14 matter as a textbook example of how individual accountability and structural reform can be pursued simultaneously, though neither is ever complete. The piece did not quote Naomi. She had not spoken to Moreau. She did not intend to, not yet. But in the final paragraph, Moreau wrote, "The woman who filed the original complaint has not commented publicly on the proceedings. People in Millhaven who were present at the council meeting describe her as composed and precise. One person who observed the hearing said, 'She wasn't angry, she was just thorough.' The investigation continues. The audit continues. In Millhaven County, the corridor between mile markers 9 and 14 is, for now, a different road than it was 8 months ago. Or whether it stays that way is a question no single hearing can answer. Somewhere in a house in Gulf Shores, a man sat on a back porch with the Gulf of Mexico visible as a flat blue line at the edge of the horizon. He had a glass of something cold. He had a pension, He had, in the past 3 months, begun checking his mail with a particular attention he had not given it before. The mail had contained nothing unusual. Not yet. And in Naomi's bag, beneath the first notebook and the second one, and the operational file, and the letter from Pruitt and the FOIA documents, and the photograph of the new notice at mile marker 12. There was a third item she had not mentioned to anyone. A copy of a case authorization memo, 8 months old, bearing a file number, bearing a jurisdiction, and bearing 2 signatures at the bottom, one of which was hers. The other signature was above a title she had not said out loud in Millhaven. Not in the car, not in the station, not in the hearing room, not at the council meeting. She had not needed to say it. The work had said it for her. The road went north. The audit was 8 weeks from completion. The letter was in the notebook. Naomi Voss-Carver zipped the bag closed, picked up her phone, and dialed a number she had not called in 3 months. It rang twice. "It's me," she said. A pause on the other end, not hesitation, recognition. "Pierce," she said. "Harold, Gulf Shores. I know where to start." The line was quiet for one moment. Then, "How long?" She looked at the window, the city, the flat morning light. "It's already started," she said. She hung up. Outside, Atlanta moved through its morning, indifferent and continuous. The bag sat on the desk. Inside it, in the second notebook, between the first page and Dana Pruitt's letter, the case number waited. Patient, documented, and not yet finished. Not anywhere near finished.